a founder, there are many different funding options you might undertake when doing fundraising. Broadly, we can split this into two categories, equity and debt. When we look at the entire deal process, we can split it into three stages. The first is the term sheet stage. The second would be due diligence, and the third would be documentation. The purpose is really just to scope out all the material issues for discussion before the lawyers actually amend the agreements. And overall, the key benefit really is to save time, legal costs, and to ensure that the negotiations are smoother and focused.
We generally advise our founders not to include terms in the legal documents just for the sake of having them there. To minimize legal costs and time, we suggest that you go straight to the investors to discuss the key commercial issues and instruct lawyers to amend the documents when these key issues have been agreed upon. We've also seen many varying forms of term sheets over our times when we deal with different VCs, investors and startups. Maybe when the company is at a later stage of your growth, and then you're talking to multiple investors when raising a round, maybe it may make more sense to send the investors your standard term sheet and tell them that this is the standard that you have shown to all the potential investors.
Our bigger law firm and wider law firm is generally more expensive. And how do you handle this?
It is true that if you use a larger law firm, it will generally be more expensive. And because price in some sense there's correlation with the firm and the partner's experience and also the branding. We highly recommend that you hire a lawyer experienced in VC at the start of a fundraising. So if the initial documents are actually not drafted well or negotiated well, it will be very difficult to change the terms in subsequent fundraising rounds, unless your company has done exceptionally well.
What will be a typical transaction cost for legal cost for each transaction?
For VC legal deals, it really depends on the complexity of the deal and the number of investors. So the higher the complexity and the higher fees.
The amount of fees you agree to cover the investor, you should also bear in mind that this should cover legal due diligence costs, legal drafting costs, and also financial due diligence costs.
So to give an illustration of the liquidation preference, we then assume there's a one-time participating liquidation preference with 3x cap. So the returns available to actually the Series A investors and the ordinary shareholders will differ based on the different points of exit valuation. So the green is the investor's return and the blue is the ordinary shareholder's return. So if you look at the left, assuming the company does not do so well, there's a liquidation event for 5 million.
In terms of liquidation preference, is it a good idea to provide 2x or more in liquidation preference?
Whatever you provide for this round, you have to apply in future rounds. So if today you are giving 2x, all future rounds you'll be giving 2x. But there are times where we see 2 times or more liquidation preference is when investors either consider the valuation to be excessive and then they want the liquidation preference to compensate for any downside risk when the company is of course having more difficulties getting support from its existing investors.
What is the typical vesting period for ESOP and how do you determine the exercise price for ESOP?
On vesting period, we typically see about 3 to 5 years. And on the discount, usually in the early stage, discount is much more substantial, maybe even up to 80%. But then as the company continues to grow and develop and more ESOP is being allocated and issued, then we tend to see a smaller discount, maybe 10 to 20%.
It talks about the lease is usually very extensive and it could hinder the operation in the future. The question is it a good idea to agree to such a lease?
We have to look at the reserve matters list from a first principle point of view. So while the list may be long, it's generally centered around matters to ensure that the business is managed well or steps are not taken to hurt the business.
It's fairly standard. Most transactions we have seen always have reserve matters. Another way is, as Hiok mentioned, is to separate the list of matters. So for one particular set of matters, you can have a different approval threshold, maybe 75%, and maybe a separate list of approval matters, you can have a lower threshold of approval.